webinar. Oh, there we go. Katie, it's 1 o'clock. I'm ready. If you are, if we have folks who are supposed to be on.
I know you have a lot of content to get through, Scott. So if we can wait 60 more seconds.
Oh, sure.
Then we'll officially kick it off if that's good.
Yeah.
Perfect. Well, good afternoon, everybody. It's Katie Haas with the Edwardsville-Glen Carbon Chamber of Commerce. I just want to take a moment to say thank you for joining us this afternoon for this webinar. Very excited to have you here. Thanks for sharing part of your afternoon with us. I think it will be time very well spent. So today's presenter is Scott Cruz. He's a labor and employment attorney with Greensfelder, Hemker Gale. And he's really going to be walking through some very important employment-related issues that are impacting this post-COVID workplace we're all finding ourselves in. So feel free to utilize the Q&A function at the bottom of your screen if you have any questions that come up throughout the presentation, and Scott will be sure to address those before we wrap up at the end of our time together. So with that, I will kick it over to Scott and let him begin. Thank you guys again for being here.
Thank you, Katie, and good afternoon, everybody. Thank you for joining me for this webinar. As Katie stated, my name is Scott Cruz. I am a labor and employment attorney, having been practicing employment law now for the past 19 years on behalf of company and management for a firm, Greensfelder, Hemker Gale. So we're in Chicago, in Belleville, and in St. Louis. Today, I'm going to be focusing on two major issues that have been affecting employers essentially since January 1, 2021. The first of those issues is with the expiration of Families First. Do you now, as an employer, if you were a covered employer under Families First, do you still have an obligation to provide paid sick or family leave to your employees if they qualify? So we'll answer that question and then talk about a host of other issues that go along with that. The second area that I'm going to cover is the COVID-19 vaccine, and whether or not we'll answer the question whether you as an employer can require, if you choose, that your employees get the vaccine as a requirement of continued employment when that vaccine becomes available to your employees. And so we'll answer that question for you and then again talk about a host of other issues. So we'll be together for about an hour and a half. So with that, let's get started. All right, so those are the two topics. Families First. If you recall, Families First required, at least went into effect on April 1st, 2020. It required that if you are a covered employer, and covered employer under Families First was defined as an employer who has less than 500 employees. So if you have 499 employees, you were covered by Families First. And if you were, it required that you provide paid sick and or family leave to eligible employees who qualified for one of the reasons under either the Emergency Paid Sick Leave Act and or the Emergency Family Medical Leave Expansion Act. Now that was a temporary law. It expired on December 31st, 2020. Unfortunately, however, as we know, the need for leave, be it sick and or family leave, if your child's school is closed and continuing to do remote learning, the need for leave continues. And the need for leave will continue, unfortunately, through 2021 and probably even beyond. So the question that we need and are going to answer right now is, as of January 1st, 2021, if you are a covered employer, are you required to provide paid sick and or family leave to eligible employees under Families First? So we'll look at our crystal ball here. Survey says the answer is no, you are not. So let's talk about this and let's peel the different layers of the onion here, because there's a lot of layers to be peeled. So first of all, why is that? As I stated, Families First expired on December 31st, 2020. That's the main reason. So what if, right? What if there is a need for leave because, for example, one of your employees gets COVID, right? What are your options, or what are the employee's options? So December 27th, 2020, then President Trump signed into law what is called the Consolidated Appropriations Act. And amongst the many provisions under the Consolidated Appropriations Act was a provision dealing with Families First that had expired the day before. And so what this provision states is that as of January 1st, 2021, if you are a covered employer, you may now voluntarily provide paid sick and or family leave to qualified employees through March 31st, 2021. And if you do so, you can collect payroll tax credits. So the mandatory obligation that we had from April 1st through December 31st, no longer there. This is purely voluntary. It is a decision that you as an organization have to make to decide whether or not you will continue to provide paid sick and or family leave to qualified employees. Now, one of the many questions I am getting is, Scott, if we do have made a decision as an organization to voluntarily provide Families First, have any of the substantive provisions of Families First changed, or have they remained the same since it went into effect on April 1st? And the answer is the substantive provisions have not changed, which means eligible employees under the Emergency Paid Sick Leave Act, they're entitled to up to 2 weeks and or 80 hours. And then under the Emergency Family Medical Leave Expansion Act, they're entitled to up to a maximum of 12 weeks, right? So that hasn't changed. The other question I get is, if we have made the decision as an organization to voluntarily provide paid leave, do we have to provide it for each of, for example, the 6 reasons under the Emergency Paid Sick Leave Act and the only qualifying reason under the Emergency Family Medical Leave Expansion Act? And that reason, of course, is if your child's school is closed or daycare is closed due to COVID-19 related reasons. Do we have to provide it for all of those reasons? The answer is no, you do not. Why is it? Because again, it's not mandatory anymore. This is purely voluntary. So I've got some clients who have made the decision, one, we are going to provide extend paid leave through March 31st, but we are only going to do so if someone gets COVID. And that is qualifying reason number 2 under the Emergency Paid Sick Leave Act. If someone, for example, a parent says, I need paid time off because Johnny's school is closed or still doing remote learning, this client is now providing paid leave under the Emergency Paid Sick Leave Act and or the Emergency Family Medical Leave Expansion. Why? Because they don't have to, right? You as an organization make that decision, 1, if you're going to provide it, and 2, for what reasons, qualifying reasons you're going to provide it. So the advice, of course, is if you do decide to voluntarily provide it and you do, the next step is, well, for what reasons? Whatever qualifying reasons you do decide, make sure you're applying that uniformly. right? You're not making exceptions. Well, we said initially we're going to provide if someone gets COVID, but we feel bad for Jody, who's a single mom, so we're going to give it to her because Johnny's school is closed. Well, guess what? You gave it to Jody for that reason. You got to give it to everybody else now as well, right? So keep that in mind. So the other question I'm getting is, what happens if someone already exhausted their allotted paid time off in 2020? Does this mean that as of January 1st, 2021, their leave banks are replenished, right? A full-time employee, do they get another 80 hours on January 1st, 2021 if they exhausted those hours in 2020? And the answer is no, they do not. However, if an employee, for example, did not exhaust all of his or her allotment, then to the extent they have any time remaining come January 1st, 2021, to the extent you have decided as an organization to voluntarily provide leave, to the extent they qualify, then they can use those hours. So let's go through some examples. Full-time employee, remember under Families First, full-time employee is defined as an individual who works 40 or more hours a week. Now you may be saying, well, that's not how we define a full-time employee in our organization. And that's fine, right? It's the hours that somebody works in a particular week is just determinative as to how many hours they get over that 2-week period. So for example, I have some clients who define a full-time employee as 35 hours a week, right? And then the 5 hours are unpaid for lunch, and that's fine. All that means is that that person was entitled to 70 hours instead of 80 hours that a 40-hour person would be for that 2-week period. So if a person, an employee, full-time employee, exhausted 40 hours last year, come January 1st, that employee has no additional hours remaining, right? They're not going to get a new batch of 80 hours, and nor are they entitled to. What about the employee who used 60 hours last year, right? Well, that employee has 20 hours remaining. So then come January 1st, if you as the organization made the decision that you're going to extend Families First, that individual, if he or she qualifies for whatever reason you have chosen, right? If you've chosen all of them or maybe one or two, then he or she could use those 20 hours through March 31st, 2021. Okay, so that's in terms of the paid sick leave, right? Or paid family leave as well. What about the payroll tax credits, right? Has that changed in any way? And the answer is no, it has not changed in the sense that in order for you to be eligible to collect those payroll tax credits, the employee must be considered eligible to get the leave, right? So what does that mean? Let's go through some examples. Let's use the example of the employee who used 60 hours in 2020. So that employee used 60 hours. You as an organization have made the decision come January 1 that you are going to, or have at least, because we're already in February, going to voluntarily provide paid leave to any employee who still has time remaining. This employee has 20 hours. You said, hey, we're going to do it for every reason under the Emergency Paid Sick Leave Act. This person has COVID, so they get 20 hours and you provide them with 20 hours of paid leave because they got COVID. This means that you can collect payroll tax credits on those 20 hours. Why? The employee is an eligible employee, right? Had 20 hours remaining and qualifies for one of the reasons under the Emergency Paid Sick Leave Act. Which is another example. The employee who used 80 hours in 2020. Come January 1st, that employee has no more hours, right? And the leave bank is not replenished. So to the extent you are being generous and to the extent you provide that employee with 80 hours, which you can do, right? You can do, because again, it's voluntary. What this means, however, is that you're not eligible to collect the payroll tax credits. Why? Because the employee is not eligible, right? The employee is not eligible because he or she didn't have any time left. And just like when Families First was enacted through December 20th, right? In order for you to collect payroll tax credits, the employee had to be eligible. In this situation, right, in my hypothetical, employee's not eligible. There's no time remaining because they exhausted the time in 2020. So if you are being generous and saying, well, we feel bad for Scott, he got COVID, he had to take the 80 hours because his child had COVID, so he took the 80 hours last year, but now he has it. We feel bad for him as a single dad. We're going to give Scott the 80 hours. We're going to pay them for the 80 hours. You can do that. Just know that you can't collect payroll tax credits because I'm ineligible for it since I already exhausted those 80 hours in 2020. Okay, so let's talk about two considerations under the Emergency Family Medical Leave Expansion Act. And again, there's one qualifying reason there. That's if the child's school or daycare is closed for a COVID-19 related reason. So a lot of my clients have been getting confused in two scenarios that I want to discuss with you in case you are confronted with this scenario as well, these two scenarios. So the first is applicable if you use the rolling 12-month FMLA period to calculate FMLA. First and foremost, you'd have to be eligible or subject to FMLA, right? So 50 or more employees. So if you are eligible, are subject to FMLA. If your organization does use that rolling 12-month period, then let's talk through a scenario. First one, let's say that in 2020, beginning January 1st, 2020, I used 4 weeks of just normal FMLA, right, for a serious health condition. And then in June 1st, 2020, I used 4 continuous weeks, again, normal FMLA for another serious health condition. And then 4 weeks on December 1st, 2020, continuous weeks for normal FMLA, another serious health condition. By my simple math, 4 times 3 is 12. I've exhausted my 12-week allotment of FMLA. All right, so now comes January 1st, 2021. In that scenario, right, if the employee says, hey, Johnny's school just went to remote learning, I didn't use any of my EFMLA time last year, I want to use it now this year. And you as an organization have made the decision that you're going to voluntarily provide leave under EFMLA. Is this employee eligible for a full 12 weeks? The answer is no. And why not? So using this rolling 12-month period, what you do is you look at the 12-month period from the date the individual wants to start the leave. So here, January 1st, 2021. You go back 12 months because then to determine how much time that individual used during that 12-month period. In my example, the person used 12 months. So what does this mean for the rolling 12-month period? Come January 1st, 2021, I'm entitled to 1 new day of FMLA. Come January 2nd, 2021, I'm entitled to 2 days of FMLA. So at the end of January 2021, I will have accumulated only 31 days of FMLA because you go back 12 months and it's a new day for each day that I took going back 1 year. It's not going to be until June 1st of 2021 that I start accumulating another 30 days. And then December of 2021 that I accumulate the last 30 days. So in my scenario here, that employee who says, hey, Johnny's school went remote learning come January 1st, they only have 1 day of FMLA January 1st and will have accumulated 31 days at the end of January. So I'm only entitled to 31 days of EFMLA through January 1st, 2021, which means you, the employer, are only entitled to collect payroll tax credits on those 31 days because that's all I have under that rolling 12-month period. Okay, let's use scenario number 2. Let's say your organization does not use the rolling 12-month period, you use a calendar year, right? So January 1 to December 31st. So let's say in 2020, I used 8 continuous weeks of EFMLA, right? Not normal FMLA, EFMLA. Johnny's school is closed. I needed time, I needed to be home with him, right? So come January 1st, 2021, because your organization uses the calendar year, well, I get a full 12 weeks again of FMLA, right? Because you're using a calendar year. Does that mean that come January 1st, 2021, I also have a new full set of 12 weeks for EFMLA? And the answer is no. Why? Because I used 8 weeks already, right, in 2020. And the leave banks aren't replenished come January 1st, 2021. Now, you may be saying, well, I thought FMLA and EFMLA are tied together. They are, right? In order for you to use EFMLA, you have to have FMLA. However, right, your EFMLA is tied to what you used last year. So while I may be getting a full new 12 weeks of FMLA come January 1, I already exhausted 8 weeks in 2020, which means I only have 4 weeks through March 31st, 2021, which means if you as an organization have voluntarily extended that leave to the employee, you can collect 4 weeks of payroll tax credits. So those are two scenarios that I want folks to be, you know how to approach that scenario, because it's a little tricky depending on what method you're using, and then if the individual used EFMLA and or FMLA the prior year. Okay, so what if, and I have many clients who said, hey, we're not going to extend paid leave because if we don't have to, we're not going to do it, right? Or you say, hey, we've got 500 employees, so we were never subject to Families First. So what are some non-Families First considerations? Because employees inevitably are going to ask, you know, I need leave, can I get paid? So let's go through some of those, some other alternatives, right? First and foremost, there's always company provided paid leave. So you have a vacation policy, you may have a sick leave policy, or you may have combined those and have a PTO policy. Well, that's always available to the employee. Consider a temporary flexible work policy, right? For the parents who need to take time off if their child's school is closed and doing remote learning. So I have one client who is not extending paid leave, but what they have done is said, hey, if you can work from home, we're going to allow you to work from home. Now, that's obviously not going to be applicable to every industry, every organization. If you're in manufacturing, for example, the machine operator is not going to be able to take the machine home to create those widgets. So what happens in that scenario? Well, what we've been seeing, at least from some savvy employees, is that they have been resigning from their employment. And then go down to the last bullet point, they've been applying for unemployment. Now, you may be saying to yourself, well, if the employee voluntarily resigns, Scott, then they're automatically ineligible for unemployment, right? Isn't that what the Unemployment Insurance Act says? Yes, it does, but the IDS has made an exception in this one scenario. And the exception is for a specific fact pattern. The fact pattern is an employee who voluntarily resigns, and voluntarily resigns based on the need to be home with their child whose school is doing remote learning, and there's no one else available, no one else at home to be with the child. And so IDS has said in that scenario, we're going to make an exception. And so the employee who voluntarily resigns and can check all three of those boxes, they are going to be eligible for unemployment, right? So there's nothing you as an employer can do about that. Certainly do not try to dissuade an employee from doing so. You can possibly be subject to a retaliation claim. But what's important for you to know here? What's important for you to know here is that employees are doing this at their own peril. What I mean by that is this is an FMLA where it's job protected leave. So machine operator who resigns, right? And let's say come March 1st, Johnny's school goes back to in-person learning. Well, that machine operator is going to come back to you and say, hey, I'm ready to come back to work. Let me know when you want me to come back. And you're going to say, we already filled your position, right? We needed somebody to make widgets. So we filled that position a week after you left. Now that employee's SOL, right? Because they don't have a position anymore. They never had job protected leave. So the employee who does voluntarily resign does so at their own peril, because ultimately you're going to need to fill that position. And if you do so before the individual comes back, not job protected leave, right? So that employee is not entitled to come back to his or her position. So just an FYI there. Local state paid sick leave. To the extent, and I don't know who's on this, I know who's on the webinar, to the extent you have a location or a facility here where I am in Chicago or in Cook County, know that there's mandatory paid sick leave here in Chicago and Cook County. If you have to provide 40 hours. To the extent I assume most of you are not, doesn't apply to you. The state of Illinois does not have a statewide mandatory paid sick leave provision yet at least. Now, to the extent you have facilities in other states, make sure you're up to date with those state laws. For example, in New York and California, those states do have mandatory statewide paid sick leave requirements that employers are required to provide a certain amount of paid sick leave to employees. So just keep that in mind to the extent you have employees in other locations. FMLA, what's the consideration here? So the consideration here is, does a positive COVID diagnosis, does that give rise to a serious health condition under the FMLA? such that you are required to provide paid or unpaid leave under FMLA. Now, you may be saying to yourself, did I just hear him say paid leave under FMLA? What's he talking about? So what I mean by that is, to the extent you have a policy that requires that employees use and exhaust simultaneously any paid company leave with their FMLA, then it's paid for the duration of time they have any company provided leave. That's what I mean by that. FMLA. Now think of it in terms of a symptomatic and asymptomatic person. Symptomatic person doesn't even know doesn't have symptoms, right? Likely not going to be incapacitated if they don't have symptoms. Likely is not going to even need treatment if they don't have any symptoms. Therefore, likely will not give rise to a serious health condition. Symptomatic person, on the other hand, depending on how severe the symptoms are, right? If I have to go to the hospital and I'm in the hospital for 2 weeks, well, I'm incapacitated. There's a need for continuing treatment of 3 or more days. I'm going to qualify for FMLA, right? So that's a case-by-case determination. ADA, what's the consideration here? Again, is a positive COVID diagnosis. Does that give rise to a disability under the ADA such that you as an employer have an obligation to provide a reasonable accommodation? And the answer is probably not, but again, case by case. And the reason I say probably not is because generally COVID is such a short duration, it continues for such a short duration that it likely won't qualify as a disability. But again, case by case. That being said, COVID in and of itself may not give rise to a disability, but remember, someone may have an underlying health condition that's exacerbated by COVID, which may, in fact, meet the definition of disability under the ADA, which means then you're required to engage in that interactive process to see if the individual is entitled to a reasonable accommodation. STD here, I'm talking about short-term disability. And what I've been seeing here is that employers have been doing 2 things. One, they have been modifying the definition of disability under the plan to meet a positive COVID diagnosis. Now, if it's self-funded plan, you can do that. If it's a plan that you have through a third party, like an insurance company, you're not gonna be able to unilaterally just amend that definition. You got to get the approval from the company, the third party. The other thing employers have been doing is they've been waiving the 7-day waiting period. So once I apply for short-term disability, I have to fill out an application. Once I submit that application, I've got to wait 7 days to get benefits. And so employers have been waiving that 7-day period so employees can start collecting benefits a lot sooner. All right, so that's topic number 1. Topic number 2 is the vaccines, right? So the vaccine is here. Let's take a minute or a couple seconds here to clap for that. We see a light at the end of the tunnel. It's shimmering, right? We can see it, but it's there and we know it's there. So good news for everybody. All right, so the question we have here is, can you as an employer, can you require that an employee get the vaccine once it becomes available? And the answer is generally yes, right? Now that is a qualified yes. It's not an unqualified yes. Why is that? Why is it a qualified yes? It's qualified because there are 2 exceptions to this general principle, which we'll be talking about. But that being said, to answer the question here, generally yes, right? A private employer, subject to the 2 exceptions, which we'll talk about, can require that their employees receive the COVID vaccine once it is available as a condition of returning to or remaining in the workplace. Okay, so there's a lot of discrepancy and a lot of misinformation that employers cannot require it. You can certainly, if you choose to do so, you can, again, subject to the 2 exceptions, which we'll be talking about. All right, and if you want, the EEOC has issued guidance back in late December of last year. If you Google EEOC guidance vaccine, this link will pop up. Click on that link, scroll down to section K as in Katie, and that will be the guidance that the EEOC issued as it relates to the vaccine. We'll be talking about a lot of that today though. All right, so the one big question first and foremost, right? So we know that we can require it, but when can we do so, right? And the EEOC has said once it becomes available to our employees. So we need to answer that question. When will it become available to our employees? So this is Illinois' distribution plan for the COVID vaccine. Now you may be saying, well, Scott, CDC has a distribution plan as well. They do, but we're in Illinois. And Illinois has the right, in fact, has adopted its own vaccine distribution plan. So don't worry about what CDC says, worry about what Illinois says, right? And what I mean by Illinois, I mean Governor Pritzker and the Illinois Department of Public Health. So as of January 6, 2021, this is here in Illinois, this is the vaccine distribution plan. Phase 1A, right, had already started. That included frontline healthcare workers, residents, and staff of long care facilities. Phase 1B started 2 weeks ago, right? June, I wish it was June, July 25th, 2021. Who is included in phase 1B? So frontline essential workers. Who's considered a frontline essential worker? I've defined that below. IDH, Illinois Department of Public Health, has stated they consider 1.3 million frontline essential workers. And then also it includes Illinois residents who are age 65 and older. This is different than what CDC had recommended for phase 1B. CDC said frontline essential workers and individuals who are 75 or older. Illinois lowered that to 65 and older. Phase 1C has not been formally adopted yet. But if you go to the Illinois Department of Public Health's website and Google their vaccine distribution plan, you'll see what that plan is for phase 1A and 1B. Right, that document just says phase 1A and 1B. It does not have yet, although they do discuss who they're going to consider and likely will be in phase 1C, who's going to be part of 1C, right? We don't know yet. There's estimates on when phase 1C will begin. Of course, that's going to be determinative on, how many vaccines we get, determinative on where you're at. But tentatively, at least, right, that's scheduled for sometime in March or at the end of March, even beginning of April. Phase 1C, tentatively, right, who's going to be included? Folks 16 or 64 with a high-risk medical condition, and then other essential workers. Who's an other essential worker? That's defined below, right? So if you are in phase 1B now, you can, to the extent your organization makes that decision, require that your employees get the COVID vaccine, subject to these two exceptions. So the two exceptions that we're going to talk about today are the following. Employees who cannot take the vaccine due to a medical disability. And the second one is employees who are seeking an exemption from your mandatory policy based on a sincerely held religious belief. All right, so what I'm going to do now over the next couple of slides is take you through a scenario where an employee comes to you and says, I cannot get the COVID vaccine because I have a disability or some type of health condition or a medical condition or something of a medical nature that makes it unsafe for me to take the vaccine. So I am seeking an exemption from your mandatory policy. In other words, what are they asking for? They're asking for a reasonable accommodation in the form of an exemption from your policy. So let's go through the steps that you are going to need to address, right, when you're faced with this scenario. So when the employee says, I've got a disability, a medical condition, what have you, what's triggered? What's triggered is the ADA, right? That's implicated here. So we need to know, right, and our obligation under the ADA is to provide a reasonable accommodation only if someone, in fact, has a disability, as that term is defined under the ADA. So how does the ADA define disability? It's defined as any physical or mental impairment that substantially limits one or more major life activities of an individual. So you're saying to yourself, great, what the heck does that mean? You're right. And so how are we going to determine whether or not someone, in fact, has a disability as defined under the ADA? Go down to the last bullet point. It's going to be determinative on what the individual's healthcare provider says, right? So you have a right under the ADA, and you should have a policy in your handbook that requires individuals, to the extent they are seeking a reasonable accommodation for a medical related reason to provide corroborating medical documentation from their healthcare provider. In the handbooks that I draft for my clients, under the ADA section, right below there, or even within the ADA section, I include a provision that states, to the extent an employee is seeking a reasonable workplace accommodation based on a medical condition, the company reserves the right to require the employee to provide corroborating medical documentation, right? So you all should have some type of provision in your handbook that gives you this right to do so. So what have we been seeing? We've been seeing doctors or medical professionals who are providing a note to the employee that says, Scott's got a medical condition, he needs an exemption from your policy. Well, what the heck does that tell you? It tells you absolutely nothing, right? Are you required to accept that? Absolutely not. So you go to the employee and say, Scott, this is insufficient. It does not provide us with any information that we need to make the determination as to whether or not you qualify for an exemption vis-a-vis through a workplace accommodation. So what we need from you is your doctor needs to identify what the condition is or to explain it in sufficient detail such that we can make a decision as to whether or not it does constitute a disability. We also need to know how this particular condition impairs you in your ability to do your job, right? Because that's the major life activity here that the person is saying, I'm impaired by based on this condition. It's I can't work, right? Because I have this condition. And then we also need to know, in addition to an exemption from the policy, are there any other workplace accommodations that will assist the individual perform the essential functions of his or her job? So there's three kind of bullet points that the doctor's notes should be addressing. 99% of them don't because they just don't want to. It's up to you as the employer to make sure that the employee knows, and then the employee tells the doctor, this is the information we need, right? So that's how you're going to determine that. All right, so let's say that you have made a determination, right, that an individual does qualify for qualifies for a disability, or it has a disability under the ADA, right? What are the next steps? And what does this mean? So it means that you believe, based on the documentation, the individual has a disability, right, or has some type of health condition that may be a disability. We now need to determine whether allowing that individual to have an exemption from our mandatory COVID vaccine policy, is that a reasonable accommodation? And if so, do we have an obligation to provide it, or does that accommodation constitute undue hardship, and or does the employee constitute a direct threat by remaining unvaccinated? So we go from the latter to the former here. Know that under the ADA, it permits us to the extent someone does even have a disability, we are not required to provide a reasonable accommodation to that employee to the extent that employee poses a direct threat to the health and safety of individuals in the workplace, and we cannot reduce or eliminate that direct threat through a reasonable accommodation, right? So the second step in the analysis is to determine whether or not an unvaccinated employee who remains in the workplace will he or she constitute a direct threat. The answer to that question is yes. And our support for that is under the EEOC and the Illinois Department of Public Health. The Illinois Department of Public Health has stated that if you don't get vaccinated, in essence, you're going to be a menace to society. The summary of that, saying, hey, you risk transmitting the virus to other people if you do not get the vaccine, right? That's what the IDPH at Illinois Department of Public Health has said. And then EEOC, back in March of 2020, has stated that COVID in and of itself constitutes a direct threat, right? So we have Illinois Department of Public Health essentially giving guidance saying unvaccinated people, right, they run the risk of transmitting COVID to others. And then EEOC saying COVID in and of itself constitutes a direct threat in the environment. So the question of will an unvaccinated employee constitute a direct threat to others in your workplace? The answer is yes, right? All right, so that's step two. Step three now is we need to determine if that employee who constitutes a direct threat, right, can we reduce or eliminate that direct threat through a reasonable accommodation? Now, some clients have been asking, Scott, before we even get there, not before, but do we have to even get to that step? We have to get to that reasonable accommodation step. Or, right, can we just automatically exclude the person without first getting into that interactive process to determine whether or not there's a reasonable accommodation? The answer is you cannot just automatically exclude someone before you go and engage in that required interactive process. So you have to do that first before you can automatically exclude someone from the workplace to the extent you can do that or you want to do that, right? So third step in the process is we undergo the interactive process, right? The interactive process is talking to the employee and determining, is there some type of accommodation, right, that will eliminate or reduce the risk of you, unvaccinated employee, posing a direct threat to others in the workplace. Okay, so let's talk about reasonable accommodations then. Generally speaking, and contrary to employees' belief, they do not have the right to accommodation of their choice. Many employees think, well, hey, as long as I give my employer this medical documentation, they have to provide it to me. And my response is, no, we don't. In fact, no, we don't, right? That's why we engage in an interactive process. And the law states, the law being the ADA states we only have to provide accommodations that are reasonable, right? And do not pose an undue hardship. Undue hardship is defined as significant difficulty or expense to the company. So what are potential reasonable accommodations that you need to consider in this scenario such that, right, the end goal being, if we implement this or provide this accommodation to the employee, will that eliminate or reduce the risk of that employee being a direct threat to others in the workplace, and the employee being the unvaccinated employee? So, couple different accommodations, that reasonable accommodation scenarios you're going to have to address. One, if the employee's positions and duties permit, if their physical presence is not required at the work site, right? It's not an essential function of the job, you can allow them to work remotely, right? Now again, machine operator it's not going to work with, right? Can't take the machine home. To the extent an individual can work from home, and you permit the employee to work from home, that is a reasonable accommodation that you are going to have to consider and likely grant that employee, right? Now, that being said, some employees have been taking advantage of this, and they've been saying, oh, great, now I'm going to use this as my get out of jail free card so that I never have to go back to the office and work ever again, right? That I'm just going to work from home indefinitely. And the answer is, that's not how it works. This is a temporary approval, right? And once we believe that the risk that you, the employee, no longer are a risk to others in the workplace, you're coming back. Or if we believe that it's just not working, right? So you're inefficient, you're not getting your job done, we don't know what the heck you're doing at home, right? You're not answering calls, you're not answering emails, we need you to come back, right? We can do so. And if the employee says, well, I can't, my doctor says I can't. And our response to that is, that means then, right, that you cannot perform the essential functions of your job, and you can terminate the employee in that scenario. That is a case-by-case scenario. It takes a lot for us to get to that step yet. I'm making it a lot more simplistic than what it is, but we can do so. What I want everybody to know, though, is the fact that you are approving someone to work from home remotely, right, as an accommodation, that is not a permanent thing. That is a temporary thing. So make sure employees understand that it can be revoked again if it's just not working out, right? Or when you believe that the employee no longer is a threat to others in the workplace. So before another consideration here is, right, for the machine operator or any other employee, even if they can work from home, is status quo. And status quo is the employee comes to work like they've been doing for the past year, wearing a mask like they've been doing for the past year, and continues to maintain social distancing, adhering to social distancing requirements like they've been doing for the past year, right? And so it's going to be very difficult for you as an employer to say, that doesn't, in our mind, eliminate or reduce the risk, Scott, of you being a direct threat. Because my response is going to be, well, why wasn't I a direct threat 2 days ago? And then only when I tell you I need this accommodation, now I'm a direct threat. I've been wearing my mask for the past year. I've been adhering to social distancing guidelines. We haven't had, as far as I know, any positive COVID-19 cases in the workplace. What has changed now? And that's a very good point. That's a very good point. And it's gonna be very difficult, close to impossible for you, the employer, to say, yeah, it's changed, Scott. We believe it's changed. So keep that in mind, that this accommodation of, coming to work, wearing a mask, maintaining social distancing, that's going to be likely the one that's in play. And that's going to be the one that's in play even for the person who wants to work from home, right? You can say, listen, unduly burdensome, right? Your position doesn't permit that. We think, you've been inefficient. So what we're going to want you to do, come back to work, status quo, put a mask on, maintain social distancing, and that's what we're going to require, right? And not only that, but what we're going to do also, to the extent we can, is we're going to put you in another role that has even less contact with other employees, or we're going to relocate your work site to the extent you can. So there's several accommodations that you're going to have to consider here, right, before you actually physically exclude someone or before you actually terminate someone, right? And the second one here, requiring someone, essentially what I'm calling status quo, come to work, wear a mask, continue wearing a mask, continue maintaining social distancing. That's the one likely that's going to be a play here, that's going to be the reasonable accommodation. Even if, quite frankly, the employee says, but I want to work from home. And we say no, right? Because you can just keep doing what you have been doing here. And that's coming to work every single day, wearing a mask, social distancing. So keep that in mind when you're going through this process, in terms of the reasonable accommodation and what's going to work and what's going to be best interest of you, the employer, but also the employee, in mitigating the risk of he or she being a direct threat to others in the workplace. All right, so let's say, before I go on to the next slide, one scenario where the status quo won't be an alternative is the employee who says, hey, you know that I can't wear a mask to begin with, right? That changes the scenario then. In that scenario, status quo isn't coming to work, or shouldn't be, because that employee is not able to wear a mask, right? And if we're not able to find another a role for that employee in the workplace, if we're not able to relocate his or her work site, then we may not be able to reduce, and the employee's position does not allow him or her to work from home, the machine operator, then we're likely not going to be able to reduce the risk of me being a direct threat to an acceptable level here, right? In that situation, right, again, the specific situation I'm referring to is the person who, for a medical reason, can't wear a mask. Then, once we've gone through that interactive process, to the extent we've determined there's nothing else we can do, Scott, right? We can't put you in any other role because you're not qualified. There is no other role available for you to do. You've told us you can't work from home. You're a machine operator. You can't wear a mask. You've told us to an underlying medical condition, right? So we believe you are a direct threat. You're not going to use that language, of course, but there isn't anything that you can do or we can do to mitigate that risk. So in that situation, now you can legally, physically exclude me from the workplace because I'm a direct threat. There is no reasonable accommodation that will eliminate or reduce the risk of me being a direct threat to an acceptable level, right? Does this mean when you physically exclude me from the workplace that I'm automatically terminated? It does not. Why? Well, first and foremost, there may be some other laws that you have, there are other laws that you have to keep in mind and consider. One of those being the FMLA, the dreaded FMLA rears its ugly head again. And so if you're subject to FMLA, right, you have to consider that if the employee has an underlying health condition that they can't get the vaccine and or have an underlying health condition that they can't wear a mask, does that underlying health condition qualify as a serious medical condition under FMLA? If so, then FMLA states that you, employer, have an affirmative obligation to offer FMLA to the employee. Now, I've been getting questions that from clients who said, okay, we understand we have an affirmative obligation, but Scott, why do we have to delay the inevitable, right? This is a permanent condition the employee has, and nothing's going to change at the end of 12 weeks. It's going to be, status quo again. Do we still have to offer to the employee? And the answer is yes. The law says if you know or believe the individual has a medical condition that may qualify as a serious medical condition, you have to offer FMLA. So then the other question is, what if the employee says, I don't want it, right? Why don't we just, you're right, it's a permanent condition, nothing's going to change. I want to, I'll resign or just fire me, right? And I'll go and collect unemployment then, right? Let's just agree to part ways here. Can you agree to part ways if the employee does not want FMLA? And the answer is no. You still have to offer it to the employee. So how do you get around this? You send the certification forms, right? The employee has 15 days to return those forms. If the employee does not return the forms for you, to complete a form due in 15 days and says, listen, I'm not going to, at that point in time, your obligation ceases. At that point in time, then you can terminate the employee and do so legally, right? So keep that in mind in terms of, when it's legal to actually terminate an employee once you've gone through those steps. All right. With all of these steps, and quite frankly, with any type of employment decision, you should be documenting each step of the process. It's important that you document because, as we know, employees will sue you, right? And our best defense to any type of lawsuit is to have documentation showing the legitimate, non-discriminatory, non-retaliatory reason for supporting why we did what we did. So make sure you have documentation substantiating your decision. So to the extent you do get sued, for example, if you terminate someone, you're going to have that documentation to help defend a lawsuit. All right, so let's now transition to the religious exemption. Know that the 3 steps that we talked about with the medical exemption, you're going to have to go through those exact same 3 steps with the religious exemption, right? So determine 1, whether or not an individual has a sincerely held religious belief. 2, direct threat, yes. 3, is there an accommodation to reduce the risk of that individual being a direct threat, right? You're going to have to go through those same steps. Let's talk about, though, this religious exemption, because there's a lot of pieces to the puzzle here that you need to know. So the scenario is the employee is going to tell you, I cannot get the vaccine based on my sincerely held religious belief, which prohibits vaccination. So what does this boil down to? The employee is telling you, I belong to a church. I'm of a particular religious denomination. I'm involved with a particular religious group, and we rely on faith-based healing through prayer, right? We do not believe in vaccinations. That's what the employee is telling you, in essence, and that's the scenario you're going to be faced with. All right, so step 1. We need to determine whether or not the employee has a sincerely held religious belief. So the EEOC does permit us to make this inquiry, but it is a very, very limited inquiry. And it is a very, very limited inquiry because that threshold that the employee needs to meet is virtually non-existent. So it's so easy for the employee to meet. If I tell you that I was at service over the past weekend and my pastor reminded the congregation that we do not believe in vaccines, we're a faith-based healing religion, that's enough. If I go to the internet and print something out and says I'm involved with this religious group, and here it says we don't believe in vaccinations, that's enough. If I give you an email, from someone that says you're the pastor of a particular church or organization, religious group that verifies that this particular group doesn't believe in vaccinations, that's enough. Now, that being said, you can certainly make sure that it's not my buddy who wrote that letter, right? So you can go onto the website, or you can require it to be in a verified statement, like an affidavit almost, right? Just to make sure the person who signed it is who they say they are. But that is the extent of your inquiry. So unless you can establish that I am getting this and getting it out of a Cracker Jack box, it is it is more probable than not that the employee, when I say more probable, 9 out of 10 times, the employee is going to be able to meet that threshold because it is that low. It is that low. So with that in mind, go down to the second to the last bullet point. I want folks to understand there's a distinction with a difference in terms of our legal obligation to accommodate employees for religious or medical reasons, and that compared to an employee seeking accommodation because of political, scientific, or personal reasons. So if an employee comes to you and says, I was watching a video from Trump, and Trump said that he's not getting the vaccine because the vaccine's unsafe. So I'm seeking an accommodation exemption from our policy. Or the employee says, I went online and I was reading this journal, I think it's a medical journal, and it said that if you get the vaccine, you're going to grow 2 heads. So I'm not getting the vaccine. Or if I tell you that, well, as the Cruz household, we have made the decision that as a family, we are not getting the vaccine. So too bad, we're not going to get the vaccine. Our response is, too bad for you. We're requiring it. And if you don't get it, you're gone, right? Simple as that. And the reason we can do that is because we have absolutely no legal obligation to accommodate and go through the steps that we just talked about, accommodate someone who is seeking an exemption for political reasons, scientific reasons, or personal reasons. If it's not medical or religious, you have no duty to accommodate that person, no duty to listen to that person, right? It is a take it or leave it, right? This is our policy. It's mandatory. If you are choosing not to get it, that's your own right. You can do so, but we'll accept your resignation effective today then, right? So that's how you handle that scenario. All right, so with that in mind, several topics have come up with employers who are seeking to implement a mandatory COVID vaccine policy. And the first issue is employees who have said, hey, I understand we have a mandatory policy, but I already had COVID, right? Why do I need to be subject to this policy? Or I've currently have COVID, as you know, and so why do I need to, or should I be subject to this policy? And the answer is yes. Now, this is not yes with my legal hat on. This is me relying on the experts, right? And the experts being CDC, Illinois Department of Public Health. And what they have said is employees, any individual, even if you have had COVID or have COVID, you should still get the vaccine because there's still a risk of you contracting COVID. Now, what they've said is, there's a 90-day period, right, after you've been infected with COVID, where it is highly unlikely that you will get COVID again. But after that 90-day period, there is a possibility that you can get COVID again. In fact, I've had clients, some health center clients, who their medical staff have gotten COVID twice, right? So this isn't just a figment of anybody's imagination. It does happen. So those employees who are telling you, well, I had COVID or I currently have COVID, am I subject to this policy? Your answer should be yes. Yes, you are. Now, what you can do, right, if you choose, is let's say you're implementing a policy next Monday, right? And so A through M is in Mary, you've got 2 weeks to get it. And then after those 2 weeks, anybody from N through Z, you have to get it. You can tell the individuals who had or have COVID, you wait a 90-day period. So unless that 90-day period expires during this next 4-week time period, you don't have to get it then, but whenever that 90-day period expires, then you get it. Or you say, you're included, Scott, your last name is C, you're getting it when all the C's get it, and that's the next 2-week period. Okay, so those employees should still be subject to your policy. And again, it's just a matter of when they get it, and that's entirely up to you. So the next question is, if we are implementing a policy or making it not mandatory but voluntary, right? Do those policies supplement, or do they replace our mask and social distancing requirements? And the answer is they supplement. They do not replace. Again, this is not Scott Cruz, lawyer. This is Scott Cruz relying on CDC experts. And the reason for this, that it's a supplement and not replacing, is that CDC has stated, or states rather, that we just don't know how much immunity even folks who get the vaccine they're going to have from COVID. Right? There's just not enough data out there for us to say with any degree of certainty that if you get the vaccine, right, that you're going to be immune from COVID forever. In fact, I read a report earlier today, and Fauci concurred with this, is that the CEO from Johnson & Johnson has said it's likely that folks are going to need to get yearly COVID vaccines for the kind of foreseeable future, just like we're doing with the flu, because there's so many new strains that are coming out of COVID that we hope, right, that Pfizer and Moderna, and then hopefully Johnson & Johnson will be able to kind of give us protection, but we don't know that yet, right? Particularly with different new strains that are coming out. And so for that reason, right, individuals, right, your mask and your social distancing requirements, they don't go away. Right, those are in place until Dr. Fauci and Governor Pritzker say that we have, and Pritzker through the Illinois Department of Public Health, state that we have achieved this herd immunity, and they give us the green light that we don't have to wear masks or social distancing anymore, whenever that is, if that ever is, right? Hopefully it is. Now, what about the employee who didn't get the vaccine? Right? Let's say, crossing our fingers that, hypothetically Fauci says and Pritzker say in September that we've reached the appropriate herd immunity level, right? In terms of enough people have gotten vaccinated, and Fauci says and Pritzker say, listen, we don't have to wear masks anymore. Again, hypothetical, and we don't have to maintain social distancing. The employees who didn't get the vaccine, they should still be subject to your mask policy. They should still be required to maintain social distancing and adhering to those guidelines. Why? They didn't get the vaccine, right? They still pose a direct threat. So people have been saying, well, Scott, isn't that discrimination? You're treating people differently. We're not, right? Think of who the two categories of people are here. While we're treating people differently, the categories of people are not protected categories under the law, right? And who are those categories? Vaccinated people versus unvaccinated, right? There's no category under Title VII that protects vaccinated or unvaccinated. There's no protected category under the Illinois Human Rights Act that protects vaccinated versus unvaccinated, right? So we're not discriminating against someone based on a protected characteristic. So that's why you can have two different policies that if you got the vaccine, we don't have to wear masks anymore. You don't have to wear them. If you didn't get the vaccine, you have to wear a mask until we say, and we believe it's safe for you not to wear a mask. So keep that in mind. All right, let's say you are implementing a mandatory policy. How do you know whether or not, in fact, I complied, right? Because you want that information, that's helpful. So the question is, can you require employees to provide proof of receipt that they got the vaccine? And the answer is yes. Yes, you can. Now, my one recommendation here, though, is make sure you are only getting the information, one, to which you need, and two, to which you are entitled. So the only information you need is this. Scott Cruz got the vaccine on February 10th, 2021. That's all you need. And more importantly, that's all you're entitled to, right? Any other information, particularly relating to my medical history, that now implicates privacy violations under the ADA. And if you're going through a third-party provider like a pharmacy, right, they're subject to HIPAA. They can't provide that information. The only way you can get it is if the employee signs a release, right? And so when employees are going to get the shot, right, they have to fill out some forms and disclose medical information. So make sure, right, you're very clear to your employees that, listen, I don't want your whole medical history. I don't care. All we want to know is, did you get it and when you got it? Right? That is it. That's all the information you need. More importantly, that's the only information legally you're entitled to get without the employee signing a medical or a HIPAA release. All right, so some legal considerations here. regardless of what you do, right, if you choose to implement a mandatory vaccine policy or you make it voluntary, make sure, just like with all of our other policies, you are uniformly applying that policy. So for example, I've got some clients who, let's say they're in the manufacturing space and their office staff are at home and that they've got folks in the plant, right? And so what they've said is, right now we're only requiring the folks in the plant to get the vaccine. Office staff, you don't have to get it yet, but when we do require you to come back, or if there's a need for you to come back earlier, right, for a couple of days, you'd have to get the vaccine, right? They're uniformly applying that policy to two different categories of people. The manufacturing facility folks who are, the machine operators, and the office staff, right? Or some clients have said, no distinctions. Even if you're at home, you're required to get it. And then people are saying, well, we're at home though, right? It doesn't matter because you may need to come in tomorrow for a specific reason. And we don't want you here if you haven't gotten the vaccine. So again, make sure you're however you choose to move forward, you're uniformly applying the policies. You're not making exceptions within the different categories, because that's when you now cannot make that you can be subject yourself to discrimination claims, right? If, for example, you say, well, in this category, there's 5 people and all 5 of them say they can't get, or they are, you're requiring to get the vaccine. And then one person says, yeah, but I don't want to get it because Trump, said he's not getting it. And you say, all right, well, that sounds like a great reason, so you don't have to get it. And that person happens to be a Caucasian and everybody else is a minority. Guess what? You've now got a discrimination claim on your hand, right? So you want to make sure, again, you're uniformly applying these policies. All right, so another legal consideration here is under the National Labor Relations Act. Now, to the extent you're saying to yourself, well, this doesn't apply to me because we don't have a union, it does, because the National Labor Relations Act applies to both union and non-union workforces. So the consideration here is a provision under the NLRA called Section 7. Section 7 under the NLRA grants employees the right to engage in what's called protected concerted activity. What does protected concerted activity means? It means when 2 or more employees act together and they're doing so to improve terms and conditions of employment. So under what context would protected concerted activity, well, you see protected concerted activity in your workplace? Well, if you choose to implement a mandatory vaccine policy, or you choose not to implement one. Let's say you choose not to implement one. All right. So what's going to happen? You're going to have an employee who's going to go on social media. That employee is going to identify who they work for, because they always do. And they're going to say, this is who I work for. And my employer clearly does not believe, or clearly does not care for the health and safety of others in the workplace, or if it's employees, because it's chosen not to make a required mandatory policy. And there's employees who aren't getting the vaccine, and we have an unsafe workplace. Obviously, you're not going to like that. So how do you address that? Or the flip side to that is the employee saying, my employer has implemented, this is who I work for, implemented a mandatory policy, and we know, everybody knows, it's common sense, there's side effects. The employer doesn't care about that. All they care about is the bottom line. They don't care about any of the employees, right? So that's a scenario you may be faced with, hopefully never, but to the extent you are. Now, your first initial reaction is going to be fire this person and request, and if first of all, request that they remove it, and if they don't, fire them. Not a good choice, either of those. If you do that, if you fire somebody or request that they take it down, you're going to subject yourself to an unfair labor practice charge under Section 7 of the National Labor Relations Act. The reason is, as much as we don't like the content of what that employee said, it is protected concerted activity. That employee has designated him or herself as the voice of other employees, and he or she is speaking on behalf of others and speaking about the workplace, particularly about the health and safety of the workplace. That is textbook protected concerted activity. If you take action against that employee, you will subject yourself to an unfair labor practice charge from the National Labor Relations Board, to the extent the employee even knows about that. So how do you handle that situation? So you approach the employee. You say, Scott, we'd like to talk to you about a social media post that we learned of the other day. Let's talk about that. We want to address your concerns. You address my concerns. At the end of that meeting, you ask me to take that post down. If I don't, you can't threaten me. You can't discipline me. Again, if you do so, you're subjecting yourself to an unfair labor practice charge. Now, what you do want to say is, Scott, in the future, to the extent you have any such concerns, we would appreciate that if you come to us first so we can have an open discussion and dialogue about these before you go on social media, right? And at the end of the day, though, does it get what you want? No, because I can say, all right, sure, but I'm not taking down my post. Now, then it's up to you on how you want to handle that. All right, so the other scenario is if you do have a union, can you implement a policy without unilaterally implement, unilaterally implement a policy without bargaining with the union first? And the answer is probably not, but I can't give you an affirmative answer because I would need to see your collective bargaining agreement. So you look at your collective bargaining agreement, determine whether or not, and look at your management rights clause in there. Is it broad enough such that you believe, or an attorney thinks so, that you have unilateral authority to implement such a policy without first bargaining with the union? More likely than not, it doesn't, right? And even if you think it does, I'd still give the union a heads up of, hey, this is what we're going to do. This is the policy that we're going to implement. We're just giving you a heads up. And if you want to sit down and talk about it, we will. But more likely than not, unless you just negotiated your collective bargaining agreement in the past, let's say 9 months, where maybe vaccines were a topic, then you did include something language in there in your CBA, but more likely than not, it wouldn't have been an area that was a topic discussed. You're not going to have anything in the CBA talking about vaccines. So in that scenario, you're likely going to have a duty to bargain with the union prior to implementing such a policy. Last legal consideration here. It's workers' comp, and there's 2 issues for workers' comp. The first is COVID related, and the second is vaccine related. So as relates to COVID, if you recall, back in June of last year, the Illinois Workers' Comp Act was amended, and it was amended to include a rebuttable presumption for individuals who file a workers' comp claim for COVID related reasons. The rebuttable presumption states that individual does not have to establish that he or she contracted COVID in the workplace, that the burden now falls onto the employer. Whereas initially, if I file a claim for workers' comp that's not COVID related, I have to, in fact, prove that I was injured in the workplace. So now the ball is in the employer's court, and the employer has to rebut this presumption that that the employee contracted COVID in the workplace. That rebuttable presumption was supposed to expire on December 31st. Based on a mutual agreement and some negotiations, it has been extended through June 30th, 2021, which means that if you're going to have an employee gets COVID, files claim for workers' comp, he or she does have that rebuttable presumption, which means now the ball is in your court to rebut that presumption that I got COVID in the workplace. There are 3 ways you can do this. The first is Scott hasn't been in the workplace for 14 days, right? In fact, hasn't been in the workplace 6 months. There's no way he got it in the workplace, right? Second is we have been complying with all CDC, OSHA, Illinois Department of Public Health guidance. If we were doing this in person, I would take a survey and say, how many of you, if you check all these boxes that CDC says you're supposed to be doing, that OSHA says you're supposed to be doing, that Illinois Department of Public Health says you're supposed to be doing. I'd venture to say more than half of you would say we're not doing that. If that is the case, and it's not an indictment on you, right? Many employers aren't, because they don't know they're supposed to be doing this, or they're just not doing it. Well, this defense is no longer available to you. And quite frankly, if you get sued based on some negligence claim related to COVID by an employee, you don't have an affirmative defense either because you're not complying with these requirements, right? So I always tell folks your best defense to these COVID-related claims is to show that we are doing everything we're supposed to be doing. CDC says we're supposed to be doing this, we're doing it. OSHA says we're supposed to be doing this, we're doing it. Illinois Department of Public Health says for our industry, we're supposed to be doing this, we're doing it. That is your defense to these types of claims, right? It is really a your defense. Again, unfortunately, many employers aren't doing it. So, all right. And your last way to rebut the presumption is that to show that I was exposed by another source, right? So you say, hey, we know that Scott's wife got COVID at the end of December. And how do we know that? Because he was using family's first leave. And so, inevitably, he probably got it from her, right? Because we haven't had any positive cases in the workplace. So he got it from her. You'll be able to rebut the presumption that way. The second consideration under workers' comp is, so if you do implement a mandatory policy, COVID vaccine policy, and the employee suffers a side effect, right? Some type of side effect from the shot. So the question here is that a compensable workplace injury? Let's go from the latter to the former. Is it a workplace injury? The answer to that is likely yes. And the reason why is because you're requiring it for me to continue my employment, right? And if I don't get it, I'm fired. So it is a workplace-related injury. Will it be compensable? TBD. We don't know. Some side effects last, a day or so. Some side effects are just pain in the arm. Some side effects are you being groggy for maybe 24 hours. Does that constitute a compensable injury? We don't know, right? It's going to be up to the comp commission to decide whether or not they're actually going to pay employees for, the side effects. What we've been seeing is that the side effects aren't bad at all, very temporary. So, maybe not, but is that going to stop an employee from trying to get some money? No, it's not, right? But again, really nothing we can do about that. It's ultimately up to, other than defend, the comp claim, it's ultimately up to the commission though. All right, so the next couple slides go through pretty quickly here. So now you have all the information you need. So the decision, of course, is should you require the vaccine? I can't answer that question for you. Only you can answer that question. I've posed some considerations for you here as to why I think you should. But there's certainly other considerations. And the one I want to focus on is the last one. So know that under OSHA, all employers have a general duty to maintain a workplace free from a recognized hazard that can cause serious harm. Well, COVID is a recognized hazard that can cause serious harm. So what if you don't implement a mandatory policy? Does an employee have a plausible argument that my employer has breached OSHA's general duty clause because they are not requiring that we get the vaccine? Thus, there's the possibility that there's just going to be unvaccinated people in the workplace who can transmit COVID to others. It's a pretty good argument. That you need to consider because it may be made by an employee and they may have a point there. Now, your response, of course, will be, well, everybody's wearing a mask. We're maintaining all the social distancing. Again, CDC says this, we're doing this. OSHA says this, we're doing this. Illinois Department of Public Health says this, we're doing this. And we haven't had any positive COVID cases in the workplace. So even though we haven't implemented a mandatory policy, there hasn't been any positive COVID cases in the workplace. So we're obviously doing something, we're doing what we're supposed to be doing here, right? That'd be an example of an argument you'd make in response to that. All right, so the flip side to the coin is we know that you can require it. Should you though? And the answer is, well, maybe not, right? Why? Again, I've listed some things for you to consider here. There's clearly others. I'll focus on a couple of these. Who's your workforce? You know your workforce. Some clients have told me, Scott, we don't need to implement a mandatory policy because our employees are biting at the chop to get it, right? They're all going to get it. They've told us they're all going to get it. We don't have to make it mandatory, right? You know your workplace. What if you have a high performer? What if you have your top salesperson who brings in, $5 million a year and says to you, yeah, I'm not getting it. What are you going to do about it? You're going to terminate that your big producer? Likely not. So So some other considerations here then, right? What I call this build buy-in and plan for conflict diffusion. Regardless of what path you take, right? Mandatory, voluntary, there's going to be some dissension amongst the ranks, right? So here's some recommendations on how to reduce and mitigate that dissension amongst the kind of rank and file. If you do make it mandatory, or if you really, really want everybody to get it, lead by example, right? Publicize that your C-suite folks have got it, upper management have got it, and guess what? They haven't grown two heads, right? By all accounts, they're fine. If it's mandatory, make sure that you're telling your employees about this before you implement it. Don't implement it today at 2:30 without having a discussion with your employees, because we know that folks are very opinionated on this and they're on both sides of the aisle. So we want to have a meaningful discussion, hence the clear communication. Again, if you want to make it mandatory, or you really, really want your employees to get it, tie it to some concrete or visible change in the workplace. So, hey, remember how everybody loved the potluck lunches we had every 2 weeks, or when we used to celebrate everybody's birthday, we get together and people bring in food. Well, we can implement that again if everybody gets the vaccine, right? So you have that carrot, right, that the people can see that they want to get, and you're tying it to them getting the vaccine. You want to provide accurate and reader-friendly information. There's so much disinformation out there on the vaccine. To the extent you are providing information to employees, make sure it's accurate. I've got one client who I thought did a pretty good thing here. They were going to implement and are implementing a mandatory policy. They met with their employees first. They got a lot of pushback from some employees who had some concerns about medical-related reasons for the vaccine. So what they did is they went out and they've got a healthcare professional who is not associated with the company, and they're holding a Zoom call. And the healthcare professional is there to kind of a town hall meeting and answer any questions that the employees have, and answer any concerns they may have about the vaccine. If you are going to require the vaccine, know that to the extent the vaccine provider is charging an administration fee for it, right? So we know the federal government's paying for it, but vaccine providers can charge like a deductible, if you will, or a copay almost, an administration fee for administering the vaccine. That could be anywhere, who knows, $20, $30. If you're requiring it, you have to pay for that. And the reason you have to pay for that is based on an amendment to the Illinois Wage Payment Collection Act in 2019 that says any reasonable and necessary business expenses that employees incur, well, that's a business expense, right? Because you're saying if you don't get it, you can't come to work here. So you, the employer, have to pay for that administration fee. If you make it voluntary, there's no obligation. But again, if you really, really want your employees to get it, pick up that fee, right? So tell them, hey, just give us the receipt. We'll reimburse you the $20. Incentivize it. I've got some clients who are providing one paid day off following each vaccine shot, right? So Moderna, Pfizer, 2-shot series. So the employees get one company provided paid day off that they don't have to use their own vacation or sick day off. Something to consider there. Other clients who are providing, and we've seen this in the news, other companies as well, providing, gift cards or some type of remuneration to employees who get it. What the EEOC has said here is that for employees who implement wellness programs, now they haven't specifically said, to incentivize for employees to get the vaccine, but back in 2009, the EEOC came out with guidance for wellness programs and said, as an example, employees can give gift cards to incentivize employees to utilize their wellness program, but they've got to, the value is going to be a modest value, right? So, $25, $50, something like that. So again, just other things you can do. All right, so that concludes the webinar today. Katie, I'm happy to take any questions now to the extent folks have questions. If there are no questions, here's my contact information. I'm happy to answer. If we went over a lot of information today, if you have any other questions, feel free to reach out to me. But if there's any questions now, I'm happy to answer them.
Well done, Scott. Thank you so much. I'm going to give attendees just a couple of a minute or so to think of questions, type any. There are not any that have come in while you were talking, which could mean you answered everything with such great detail that no one has anything left stirring on their brains. Or once they take it back to their team and think about it, they may have some that come up. I also want to mention that this webinar is recorded and was recorded, and that will be shared with attendees as well. So if they missed something, they need to go back, they want to clarify or verify something, they will have the opportunity to do that as well. Okay, I don't see any questions, and I don't. So, Scott, I think you did a fantastic job answering anything that they wanted to know. Oh, just one second. Just a great compliment. Everything was great. Thank you so much, Scott.
Oh, you're welcome.
Those are the best kinds of Q&A.
Those are the best kinds. I can answer those pretty easily. Thank you.
Fantastic. Okay, well, I think that wraps up the session today. Again, thank you so much for your time and expertise. You know, for chamber members, having access to this high quality vetted information is, you know, a huge benefit to being a member. So we appreciate you sharing your expertise with us in that capacity. So thank you again.
You're welcome.
So I think that's all I have to say. I think, Scott, you can take a break now. That was a lot of information in an hour and a half's time. So I think we're good for the day, and thank you again. Certainly, thanks for providing your contact information. If anyone has specific questions or scenarios they would, you know, like your thoughts on, you made it very easy to get in touch with you. So thank you again for that.
And we'll provide the slides too. So I'll send that to Katie so she has it.
Perfect.
All righty. Well, thanks everybody. Have a good rest of the day.